Hello, thank you for joining us for the 23rd Annual Virtual Elder Abuse Conference, Serving Older Adults During Times of Isolation. This conference is presented by the Syracuse Area Domestic and Sexual Violence Coalition's Elder Justice Committee. My name is Lori DiCaprio-Lee, and I am the ID Theft and Outreach Coordinator at Vera House. Before we begin today's presentation, I'd like to acknowledge some recent events. The COVID-19 pandemic has highlighted issues of inequality. Older adults, those who live in poverty, and members of Black and Brown communities have been more severely impacted. The Elder Justice Committee values all older adults and stands in solidarity with the Black community. We pledge to uplift the voices of Black people in our community and strive to fight the injustices that have led us to this moment. Thank you. Moving on to other announcements. All webinars during this conference are free thanks to the generous support of our sponsors. And I want to particularly recognize our platinum sponsors, Loretto and the Onondaga County Department of Adult and Long-Term Care Services, our gold sponsors, Syracuse Jewish Family Service and Wegmans, and our silver sponsors, the Alzheimer's Association of CNY, At Home Independent Living, Community Bank, Countryside Federal Credit Union, Crouse Health, Fulton Savings Bank, the Syracuse University School of Social Work, and Touching Hearts at Home. More information about all of our sponsors can be found on the Vera House website. The support of these sponsors not only funds this webinar series, but also extends beyond the conference to continue elder abuse education and prevention outreach after the event. Today's webinar, one last announcement before we begin. The chat feature is disabled, however, you can ask questions using the Q&A. Today's webinar is Court Challenges During COVID-19, and we have three presenters. They are Jordan Aiello, Assistant District Attorney at the Onondaga County District Attorney's Office, Melanie Carden, Senior Assistant District Attorney at the Onondaga County District Attorney's Office, and Morgan Thurston, Assistant Welfare Attorney at the Onondaga County Department of Law. And so with that, I will turn it over to our speakers.
Hi guys, my name is Melanie Carden. I'm a Senior Assistant District Attorney at the Onondaga County DA's office. By way of background, I have worked here for almost 12 years. Started out in City Court, where most of us start out, spent several years in the Special Victims Bureau, and now I spend my time in the Financial Crimes Bureau. Elder abuse, the way that we deal with elder abuse in our office is it's actually split between two different units. So sexual and physical violence is dealt with through the Special Victims Bureau, and Jordan is currently our resident SVB elder abuse expert. And the financial exploitation is dealt with through the white collar or the Economic Crimes and Rackets Bureau, where I am. So getting started, Lori, you can change the slide for me, thank you. So to give you a bit of a context before we get to what's changed about the court process because of COVID, I want to give you a background in terms of what we do as part of the investigative process in either special victims or financial crimes cases. So essentially, the case starts because a complainant files some sort of disclosure or a complaint with whatever agency it may be, whether it's district attorney's office, police agency, they make a disclosure to Adult Protective, and that's really what initiates the investigative process. So as part of that, we do work closely with Adult Protective, and many of our investigations are done in conjunction with them. And the next step from disclosure is to go out and actually secure the evidence. And what that means is there's two different kinds of evidence. There's direct evidence and there is circumstantial evidence. So basically any good investigation is going to go out and try to find both. What that means is we talk to people, we interview witnesses, so people's statements, what they actually saw happen, that is evidence. There's actual physical evidence, whether it's forensic, collecting forensics, actually going in, executing a search warrant, taking, looking around at what's in the home. And then there's documents and whatnot, particularly in elder abuse cases. We want to get financial documents, medical records, all of the paper that we can put our hands on that really substantiates the complaint. In addition to that, any good investigation is also going to look for corroboration. And what I mean by that is, if you've ever heard the term, okay, well, it's a he said, she said, or it's, one person's statement against another, what we try to do is really go out and find evidence, whether it's, like I said, direct evidence or circumstantial, that substantiates what one person versus another is saying, right? So it makes it a much stronger case when we can actually say, okay, well, she said that this happened, he's denying it, but there's all this supporting stuff that we were able to go out and find, and it really supports her story and completely refutes his. So again, any good investigation, we're going to go out, we're going to get the direct stuff, and then we're going to take a step back, look at what we have, and try to find kind of additional places that we can look to get that substantiation. Next slide, Lori. So like I said, with that background, so now what has changed because of COVID? So the investigative challenges that we're facing in large part are that there aren't as many opportunities to actually make those disclosures. And this is true for any number of types of cases when you're talking about whether it's child abuse or adult sexual abuse, physical abuse, whatever. The safe places that people go to, schools, senior centers, banks, those places are closed right now. So in terms of having a person to whom a victim can actually tell what's going on, those opportunities for interactions are very limited. The other issue with those places being closed is that those are often the people that we go to find some of that corroborative evidence as well. So with the example of a bank, if you have a teller or a bank manager who's familiar with your victim and also your perpetrator, and they observe the perpetrator coming in and bringing the victim in and kind of bullying them into taking money out, those observations by the bank teller and bank manager employees are extremely important. So the fact that some of these places are closed and the opportunity for those for actual external witnesses to be seeing what's going on, it really does make it for a more challenging investigative process. In addition, one of the biggest challenges that we're facing is that we as law enforcement agencies, and I would argue probably with adult protective as well, we really ideally like to conduct our interviews in person. And so it allows people to build rapport, makes people more comfortable talking to somebody that they can sit across from face to face and develop a relationship with. And so we're obviously balancing the risks of exposure, particularly with our elderly victims, in a situation where we're facing a pandemic where this is the most vulnerable population if they were to become infected. So really balancing that risk versus continuing to allow any sort of victimization to occur. We have to take those into account when we make the decision whether to do an in-person interview versus over the phone or by some sort of video conference. In addition, the best practices in terms of in-person interviewing would suggest that the interview should be done slowly, and the interview should be mainly to allow that rapport building to occur, but also to allow the person to really give you the information at their own pace and not feel rushed during the interview. Again, when we talk about elderly victims, we always have to take into account capacity. And sometimes that also requires multiple visits to try to find a time during the day that a person is more likely to be able to talk to you. So, do we go in the evening? Do we go when they first wake up? Do we go after they've taken their medicine, after they've had lunch? All of those factors might require really trial and error to figure out when the best time is, which of course means that you're exposing people more often. And then, the obvious issue is that securing all of those documentation, the medical records, the bank records, whatever it may be, staff has been furloughed. These cases, investigations are not necessarily people's priorities. It's keeping their own employees safe, making sure that they're complying with COVID restrictions, and also making sure that their business is still running. So whether it's because the businesses themselves are closed or not staffed, or it's just not a priority, getting those documents has been a challenge. Next slide, Lori. So the specific to financial cases, our investigative process to really determine whether financial exploitation has occurred means that we have to find a pattern of spending. And ideally, we should be looking at a pattern that predates the participation of the person who's been accused of exploitation, right? So we have to go back to get a baseline of what is normal for our victim. What do they usually spend money on? And then hopefully be able to talk through with them, okay, I go to Wegmans and I get my hair done, and every other week, or whatever it may be. And then hopefully we would be able to observe a distinct change in the spending pattern when our perpetrator enters the picture. So that pattern location is extremely important in terms of the investigation. The problems that we're starting to face, and I shouldn't say that we are facing them yet, but I anticipate that this is going to be something in the future as the world opens up a little bit and we maybe start getting disclosures about financial exploitation that happened during this time period, is that the patterns during shutdown are going to be very different. So the pattern of spending, just by virtue of the fact that people aren't able to get out, is going to be different. There may actually be legitimate times when the household should have been sharing expenses. So if the perpetrator is somebody who ends up quarantining with the elderly victim during this time period, there's an argument that their household expenses maybe should have been shared, and that time period was not so much exploitative as much as necessary to run a household. So it may be that that may be a defense that we can either confirm or refute, or it may be that if we take a look at the finances and our victims give us information, that kind of the time period where people were living together under these restrictions may need to be analyzed in a different way than other time periods of spending. And again, similar to going out and actually getting these documents, our investigative staff, whether it's our agency or any of the police agencies, the investigative staff is reduced and obviously prioritizing different things right now. Next slide, Lori.
I'm Jordan Aiello. Mel introduced me. So I'm in the Special Victims Bureau, and I handle the sexual and physical abuse cases with elderly victims, in addition to cases with children and domestic violence cases. One of the biggest issues that we've been facing is being able to meet with victims and where we can do that. So for both investigations and post-arrest, since the middle of March, we've been limited to one location. We've been using the Child Advocacy Center. That's not a guaranteed place that we can use. Obviously, it's required that people wear masks, and it's also required that somebody can answer no to all of the questions as to whether or not they've experienced symptoms or if they've been in contact with somebody who might have been exposed to COVID, and whether or not they've been out of the country. If they can't answer no to all those questions, there's not going to be any in-person meetings with them. And if they can, then it's a possibility. But of course, there are all of the pros and cons to that we're going to have to consider before we actually make that decision. Obviously, there are a lot of benefits to in-person meetings, whether it's a police officer investigating a case before arrest, or if it's me handling a case that's already been arrested and I'm just trying to meet with the victim. Establishing a rapport and getting to know somebody in person is much easier than doing it over the telephone or even doing it over Skype or Zoom. It's hard to develop a good relationship with somebody just in an electronic means without, especially when you're talking about cases that are very sensitive and people are talking about the worst moments of their lives or something terrible that's happening with a close family member. So my preference whenever possible is to do it in person. It's not even ideal in person, honestly, because It's even sometimes hard to do those things and create that relationship when you're both wearing masks and you're sitting as far away from each other as possible and you can't shake hands when you meet somebody, but it's much better than doing it over the phone. And another benefit to being able to do it in person when you're talking about a physical abuse case is to take into consideration if there were any physical injuries. You want to get a victim to see a police officer and get photographs taken of those injuries whenever possible so that they're appropriately documented. We know exactly when that injury was on the victim, exactly where it was. It can be measured with a ruler next to it so we know the size, and all of that is appropriately documented if there's going to be a trial in the future, or at the very least, it's compelling evidence for a defense attorney to look at when you're talking about the case further down the line, and it's strong corroborative evidence like Melanie was talking about that you need for cases. Of course, if you have no other option, you could have a victim take those photographs of themselves, but there's going to be a lot more challenges to them down the line. There's going to be a lot more questions about, well, when exactly did you take that photograph? Well, is that bruise as big as it looks, or did you just zoom in on it to try to make it look big? There's going to be a lot more questions. So that's just another investigative benefit to being able to meet with people in person. And you can never forget about how important it is to have a discussion with someone face to face in terms of judging their credibility. I never go very far in a serious case before meeting with the victim face to face, so that they get to know me and trust me, and I get to know them and trust them. It's hard to evaluate credibility and for them to judge my credibility just over the telephone. But of course, in the age of COVID, there are big risks to meeting people in person. And especially when you're talking about elderly victims, you have to consider whether or not it's worth possibly exposing them, even though we're trying to do everything as best we can. And due to that, you kind of want to take into consideration, is this victim in immediate danger? Is this something that maybe it could wait until things are a little bit safer in the world to meet with them? Or are they possibly in danger right now? And so we need to maybe take that risk and we need to meet with them and move things forward right now. Another thing that we need to take into consideration, and I'll talk about a little bit more in a later slide, is what's going to happen post-arrest, involving specifically what is going to be asked of the victim in terms of future exposure. And I'll talk about that a little later on in more detail. And lastly, a large challenge is that there are limited support networks. I've spoken to quite a few victims on the phone and a couple in person where they've told me that, they're looking to get into therapy and get counseling. And that's not an easy thing to initiate right now if you don't already have somebody that you have a relationship with. You're talking about domestic violence. Either the victim or the perpetrator might need to find new housing if you're going to separate those parties. And that's not an easy thing to do right now. Further, a lot of times in domestic violence cases, you have substance abuse or mental health issues that are at the root of things. And again, that's just another thing that it's more difficult to get somebody somewhere to start getting them that help. Next slide, Lori. So here we put up a picture of like the criminal process tree. So it shows you the steps that generally happen or the options that can happen after a crime has occurred. So first a crime is committed, and then through some sort of disclosure, there is a police investigation. Generally, it starts with the police. There can be a district attorney's office investigation, but most of the time it's the police. After the police investigate, they can either say, we don't think a crime was committed, or we don't have enough evidence to substantiate that a crime was committed and there's no arrest made. Or there is enough evidence and they believe there's been a crime committed and the defendant is arrested. After the defendant is arrested, they are very quickly arraigned. At an arraignment, typically is when a judge assigns an attorney, and if any bail is going to be set, then the judge sets it. And 99.9% of the time, a defendant pleads not guilty at an arraignment. After arraignment, if it's a misdemeanor case, then it's just a misdemeanor is something that someone can be sentenced to a year or less in jail for, and a felony is something you can get more than a year in jail for. So if it's a misdemeanor, after arraignment, it's pretty much ready to just be put on the judge's calendar and start being heard, and everyone can decide where it's going to go from there. However, if it's a felony case, then there are more steps that need to be taken. If a defendant is in custody, then in order to keep them in custody, the people as in me and Melanie have to either have a preliminary hearing or put the case in front of the grand jury. A preliminary hearing requires a witness to testify about what happened. A witness who has non-hearsay allegations against the defendant, which means they saw something with their own two eyes. So generally in these cases, that means the victim. A police officer's testimony in most cases won't be enough in a domestic violence or a sexual or physical abuse case. And the judge decides at that point if there's reasonable cause to believe that the defendant committed a felony and whether or not they stay in custody. And that is something that happens in an open courtroom. So there's a judge, there's the witness, there's the prosecutor, and then there's the defense attorney and the defendant. So that person that just a few days ago committed a crime against that victim is sitting in the courtroom and staring at them as they testify about what happened. The other option is grand jury, and that's preferable because it's preferable for some reasons, because there's no judge and there's no defendant and there's no defense attorney there. It's a group of 24 people. They're sworn to secrecy, and the witness answers the prosecutor's questions in that room. And after that, the grand jury decides if there's reasonable cause to believe that the defendant committed a felony. And if there is, then they, again, stay in custody at the bail that was already set. Problem right now is we don't have grand juries, which means that that's not an option right now. So if someone's going to be arrested and if they're held in jail and we want them to stay, our only option is that preliminary hearing. So that's something that needs to be taken into consideration when investigations and arrests are happening during COVID. After grand jury, if they do find reasonable cause to believe, then there's an indictment. And if they don't, there's a no bill and the case is over at that point. If there's an indictment, that's when the case goes in front of a judge, and then either the defendant can plead guilty, and if they plead guilty to everything, they can accept what the judge wants to offer them. If they plead guilty to just one charge, generally that's plea bargaining, and it's what the people are offering them as a sentence. Or if they don't want to plead guilty, then they can go to trial. If they're found not guilty, they're acquitted, and that's it, it's over. Or if they're found guilty, then it is up to the judge to sentence them. And then they are sentenced either according to what the judge promised them or what the people promised them, or it's just completely in the judge's discretion if they went to trial and were found guilty. And then after sentencing, they do get the chance to appeal. So there's always the probability that maybe something went wrong at one of the stages that I've already talked about, and then we have to go back and start over again. Next slide.
So the challenges that we've been encountering, just in terms of, oops, let me turn my phone down. The challenges that we've been encountering during this process, in addition to the ones that Jordan mentioned, obviously we don't have grand jury right now, but the negotiation and discovery phase tends to be very important as well. And discovery is the point at which the people essentially turn over all of the evidence and all the proof that we have against the defendant and give that over to the defense attorney so that they can really have an intelligent discussion about what we have against them. So the issue becomes many of the attorneys in the area closed their practices during this time period. So actually getting a hold of people was very difficult. Once we were able to get a hold of people, having the attorney wasn't necessarily able to have functional and good discussions with the defendant because they couldn't sit down on the same room. So really, anytime where there was a point where either we needed to communicate with somebody or the defendant needed to communicate with the defense attorney, that has slowed down to just a grinding halt. As I said, there has been quite literally some attorneys just haven't picked up their phone for the entirety of the shutdown. So negotiating with kind of absentee defense attorneys has created a little bit of a backlog. So far, although this is kind of changing and is becoming a little bit of a moving target, in normal circumstances where we encounter some of these challenges, if attorneys are not negotiating or we don't believe that they're actually communicating offers to the defendants, we have the opportunity to get a court involved to make sure that the right thing is happening. So called a negative plea allocution. Essentially, you bring all of the parties in front of the judge. You say, hey, people's offer is this. We want to make sure it's been communicated to the defendant. He understands the pros and cons. And at least then on the record, you can have the defendant say, yes, I spoke to my attorney about it and I'm rejecting the offer. Or sometimes they say, you know what, I didn't understand it completely and I'd like to take it today. But that's not possible right now because we don't have in-court appearances, or very limited cases are allowed to be heard in court. As Jordan mentioned too, the threat that, okay, well, if you don't take my offer, I'm going to indict you, I'm going to put this in front of a grand jury, is non-existent right now because we simply don't have grand juries. So there's really no motivation for defendants to negotiate with us when we know that they know that we can't do much of anything if they just, refuse to participate. Jordan mentioned earlier, obviously, that the, assessing credibility of your witnesses and your victims has been difficult because having those in-person conversations has been tough. And then one of the issues that we've encountered as well, and again, particularly with elderly victims, is what's called a conditional exam. So a conditional exam is a process that allows you to secure and preserve testimony of a witness if there's reason to believe that they're going to be unavailable for trial. So we've had situations where because of advanced age and medical conditions, some of our victims have taken significant turn for the worse during the pandemic, and not necessarily related to COVID, just because their health was deteriorating. Because this is already a vulnerable age population, and now we're adding on top of it people who are quite literally suffering health difficulties, we had to really be very careful about whether we ended up going in and conducting that conditional exam. Because different than a witness interview, a conditional exam actually allows the defense attorney to cross-examine the witness. So there's more people involved, there's more risk of infection. Luckily, the case I'm talking about in particular, the defendant did plead guilty, so we didn't have to take that step, but it was something that we were very likely going to have to do. Next slide, Lori.
So, when you're talking about elder abuse cases, the vast majority of the time, you're talking about a perpetrator that is a family member. And this goes for, sexual, physical abuse cases, as well as financial cases. It's very rare, actually, that just one of those forms of abuse is occurring in an elder abuse situation. Generally, they're intertwined, and if there's a perpetrator, they're taking advantage in more than one way, and they are most of the time a family member or somebody that is very close to them and in a trusted position. And along with that comes all of the dynamics that there is in every domestic violence case, where the victim has a very close relationship with the defendant and they love them. There's a codependence between the parties. So the victim has a lot of things that they're going to be afraid of if they disclose. They're afraid of what they might lose, if they're going to have a place to live, if they're going to have enough money to take care of themselves, if they're going to have somebody else that will take care of them, if they're an elderly person that depends on someone else. And like I said, they love the perpetrator. So they're also probably going to be afraid of what will happen to the perpetrator if they tell the police about what's going on. Because to them, that's somebody that's not all bad. They see the good part of them too, and they don't just want them to get in trouble or go to jail a lot of the time. or a lot of the time they don't want them to have a criminal record to ruin any chance of a future. So there's a lot of different emotions and considerations that go into play, even in normal times in a domestic case. And it's very difficult now because we have a very uncertain future. As I said before, there's less of an opportunity for rehabilitative programs. For people who have substance abuse or mental health issues, it's harder to get people into those kinds of programs. There's no domestic violence classes happening right now. So it's, not something that we can tell a victim that we can immediately start moving forward and try to get that perpetrator help, because that's probably not going to be possible right now. That also limits our opportunity to actually provide support to the victim, because there are support systems for them that aren't in place. I know I mentioned before, specifically possibly therapy or housing, a lot of different things that they're not going to have access to. There is no opportunity for court intervention right now. Courts are still only hearing very limited cases and what they've deemed to be essential matters, which generally most of it is bail reviews. We're expanding a little bit now, and I'll talk about that at the end in terms of what courts are hearing, but orders of protection aren't really on that list. So most of the time the issues I've had is I have victims that call me up and there was a full order of protection that was issued at arraignment, and they want that to be changed. They want to have a partial order, or they want to have no order so they can have contact with the defendant. And courts aren't putting that on their calendar right now. That's not something that is going to be in front of a judge probably anytime soon for it to be amended. And that also goes the other way, that at arraignment, orders of protection are issued temporarily as a full order, and we're not having courts keeping tabs on that to automatically extend them right now either. That's not a reason that they're putting cases on. So there are a lot of challenges in that domestic scenario in terms of what is available to us at this time. Next slide, please. I mentioned before that there's no grand jury and what that means with a case. What that means is if someone's held in custody, then and you want them to stay in custody, then you're going to have to run a preliminary hearing. Preliminary hearings are a little different right now than they generally are. They're not in the open courtroom, they're done over Skype. So the judge is on Skype, the defense attorney is separately there, the defendant is there at the Justice Center, and then the victim or witness comes to the district attorney's office, and the witness and the prosecutor are together on Skype, and the witness is questioned that way. So in a sense, it's a little less intimidating, as they're not physically in court with the perpetrator, but they're still going through the same thing. They still have that defendant staring at them on the screen. They're being asked questions by the prosecutor, and then they're being cross-examined by the defense attorney. And the thing about that is that even if that defendant is then held in custody, if in the future the case isn't resolved with a guilty plea or something else that's satisfactory to everybody, we're still going to have to go to grand jury. Having a preliminary hearing doesn't eliminate the need for grand jury. So when we get grand juries back, then that witness is going to have to come back again and testify about what happened once more. So it's just an additional re-traumatization that happens to a victim because we don't have an alternative option right now besides allowing somebody to be released from jail, which, depending on the circumstances, may or may not be the right thing. So it's something that we need to consider pre-arrest. Just like I talked about in terms of balancing the pros and cons of conducting an investigation, we need to then balance the pros and cons of whether or not that person should be arrested at that moment. We have to consider what we can actually get out of an arrest at that moment, and what we can make happen and what good can come of it, because it's very difficult to get things moving right now. And then think, is it worth this possibility of re-traumatizing the victim and trying to push forward when we're probably just going to be at a standstill anyways? And of course, the fact that I mentioned already that, once grand jury is returned, that witness and victim very likely is going to have to come back to testify once again. And all of that is just delaying the start date for getting us to what would ultimately be a trial if there's never any resolution, or at least getting us to that indictment phase so that a defendant gets in a courtroom in front of a judge and realizes, what their best options are, and then maybe pleads guilty. We're delaying we're delaying closure for the victim, and we're delaying any times that they might have to testify again, and keep dealing with, the events that happened on the date of the crime over and over again. Next slide.
So I'm going to go pretty quick because we're cutting into Morgan's time a little bit, but I want to at least briefly explain what a plea bargain is, because it's an important part of any negotiation process as we go through the criminal cases. But basically, a plea bargain gets a bad reputation. However, it really allows people to buy control over the case. So if I give up prosecuting somebody for the top count, I have purchased, with that thing I gave up, I have purchased control over the sentence. It buys certainty for all of us. And the factors that we generally take into account with any sort of plea bargain is what type of plea we want somebody to enter, whether it's a violation or a misdemeanor or felony, the type of sentence we want them to have, whether they've made restitution, and how they're going to do that. And then for sexual cases, we think about whether the person is going to be a sex offender, a registered sex offender by virtue of their plea. And then we balance that against the risk of the judge undercutting us, because if we don't give anything up as the prosecution, if we throw the book at somebody and say, okay, plead guilty to everything, I'm not going to give you any sort of reduction, then it takes that control out of our hands and the judge can sentence somebody to anything. Next slide, Lori.
Before we move on, we had a quick question that I think is relevant right now. If charged at a preliminary hearing, why do they need to go through a grand jury too?
Because New York State, so basically it's the difference between, we cannot announce ready for trial on a case until it has gone through indictment. So it's a necessary step in the process of actually taking a case to trial, is that review by the grand jury.
The sole purpose of the preliminary hearing is to determine basically whether or not that person's staying in custody. There are no preliminary hearings on other cases if someone's out of custody.
Okay, thanks.
Is this you still, Mel? Oh, sorry.
Yeah, so in terms of, like I said, the factors that we consider towards a negotiated disposition were those factors on the last slide. In the moment that we're looking at right now, financial cases, we're always trying to get restitution, but it's unlikely right now. The stock market's unstable. People generally try to raid their retirement accounts, and that's just not a factor. And obviously people aren't making money in the way that they were. Jail is less likely. Both, I think our own offers have changed a little bit in the judge's offers, just in terms of being consistent with public policy and public health policy. I think we're seeing fewer jail sentences. Probation, however, is kind of a risky sentence as well, because in terms of allowing somebody the opportunity to pay restitution through probation, we as the people have to be able to show that they have the ability to pay restitution. And if they don't have the ability, they can't be ordered to pay. The flip side of that is, at the end of a probationary sentence, if we haven't adequately shown and the judge hasn't made a finding that somebody actually has the ability to pay, they can't be jailed for not paying. So it's great, we give people the chance, but there's not always necessarily a hammer hanging over their head if they don't comply. And then last but not least, even if we have managed to actually negotiate a disposition, the lower courts are closed and those dispositions are just sitting out there waiting to be scheduled when things open back up. Next slide.
And then I'll go through this quick so we can get to Morgan. So one thing that we will also need to consider once we have grand juries again, is it worth the indictment versus what we might be able to resolve short of indicting a case, because grand juries are going to operate quite differently. First of all, they're going to have shorter time frames where they're actually serving on a grand jury. Right now, the way they used to work is they used to be, I think, a month, maybe even closer to 2 months, where a grand jury would be there, and that's not the plan. Once we get them back, grand jury, like I said, is 20 plus people in a room, so we need to figure out a format to get everybody to be not right on top of each other, and to have a grand jury for a shorter period of time gives you less investigative chances with that grand jury, and it rushes an indictment a little bit more than often you'd want it to be rushed. Also, you're exposing your witnesses and victims and the grand jurors to each other, and that's another thing that you have to take into consideration. And finally, the state of things right now, everything has been administratively adjourned since March. Courts are adding things slowly. So in addition to bail reviews, they are now agreeing to hear cases where the defendant has agreed to plead guilty to a felony with an agreed upon disposition. But again, only if those have already been agreed to, not just to see what they think about it. Hearings are going to resume electronically for now. So again, through Skype. And we still, we don't know exactly when jury trials are going to be back, but probably not until very late this calendar year, if it happens this calendar year. And I'll leave it to Morgan.
All right, thank you guys. I'm Morgan Thurston. I'm assistant welfare attorney. My role at the county is I'm the attorney for adult protective services. So I do the guardianships for the county and other interventions that adult protective can undertake. I'm going to mirror some of the stuff that Melanie and Jordan said, because about delays in getting one of the important things our workers do for adult protective, it's about relationship building, and there's been a lot of limitations there. I'll get to that. This first slide, I just put it up here, and actually there's some differing dates depending on where you're looking, but what happened is we had a systematic shutdown, essentially, of the courts except for essential matters. The governor issued an order on March 23rd. Actually, locally, we said March 16th that the courts were closed to non-essential matters. That became kind of an issue to say, okay, what's essential? Jordan and Melanie touched on the criminal aspects of what they were able to continue to do. For most of what I do, most of it's non-essential. I had to make some, I made one emergency filing, and some we kind of wavered on whether we could say they were actually an emergency. And I'll talk about that in a second too. But we've been slowly coming back, and part of it has been virtual court appearances, and Jordan mentioned by Skype. And in a criminal setting where you have some controls, maybe someone's in custody and attorneys having access and the DA's office having access to their witnesses and victims set up. In civil practice, this has seemed to me much more disjointed. I don't think we've had the same capabilities. The county does have some access. I've actually appearing today on a camera I went out and bought myself so I could make sure I could appear in court via Skype. And it's been a little bit different process than what we're doing today on a Zoom webinar. So I was actually in court yesterday on a hearing via Skype, and the court could not get its recording function to work. Surrogates court matters are recorded like family court. There's no stenographer, it's just electronically recorded. They could not get the function to work, so we could not go on the record. We had to have an off-the-record conversation. So that was just one example of not being able to proceed. Slowly, we've been coming back. Virtual court was expanded to non-essential matters in April. In May, court staff started to return, and we also had the ability to restart filing non-essential matters, which was allowing me to start some of the filings I couldn't undertake. We went to phase 2 in June, and June 16th, the courts in 5 upstate judicial districts began phase 3. And that's on, phase 3 is actually the next slide, if you could do that, Lori. So we're technically in phase 3 right now. I think we'll be going to phase 4 quickly with the courts. for upstate, but they were handling more things like child support proceedings, more criminal stuff, preliminary hearings that Jordan and Melanie were talking about, arraignments of defendants, limited number of bench trials in civil matters, no jury trials in civil matters right now. Essential family court matters, they were continuing. A lot of those were deemed for child abuse, and some custody matters were continuing on. What they want, though, is the judges to continue to expand their use of virtual proceedings whenever legally permissible and possible. So I think this isn't going to change for a while for us, even though as we go to phase 4. I spoke with Surrogate's Court employee yesterday, and they believe that we will be having more ability to go into court physically in the near future, but it's going to be encouraged and strongly, not pressured, but encouraged to us to appear remotely as for attorneys. For people without representation, I think they'll be able to return more on their own. Next slide. This was mentioned too by Jordan and Melanie. Temporary orders of protection were extended. Jordan pointed out that's maybe not necessarily a good thing because you're not having the court involvement. It could be a good thing that you don't have to worry about it expiring. So if you had an order of protection, it's still in place. Pending evictions were stayed. Deadlines were extended. Statute of limitations were told. So if you needed to commence a legal action, that has been pushed out too. So your civil legal rights aren't being hindered by the COVID and the shutdown of the courts. Foreclosures also, not just evictions, but foreclosures were stayed. Some of these are real benefits to our vulnerable clients that Adult Protective deals with. So if they couldn't be evicted, and I want to give the time frame on this, the actual time frame for staying these matters expired on June 20th. What the court said was that until July 7th, they really couldn't serve any new summons or file those actions or subpoena or summons on those actions. And what they also said, if you could show that you're economically affected by COVID, it is going to be stayed until August 20th. So another extension out into middle of August for a lot of evictions and a lot of foreclosures. Some of our fears, though, is that for our vulnerable populations, is that landlords may have not, even though they may have known about the evictions being stayed, they still may have illegally given notice to our vulnerable clients, and they may still have left without knowing what their rights were. We have seen that happen before, and we're sure that it probably is happening out there right now. The double-edged sword here would potentially be, what if you had a client that was an elderly client that was dependent on rental income? They had a 2-family house, and the tenant just stopped paying, and they couldn't do anything to protect those civil rights. So that's with every thing that we see as a positive, there's generally another effect as well. Next slide, please. So what's the effect on Adult Protective and our clients by having the courts limited or closed? Part of what Jordan and Melanie said was our ability to investigate. Our operations were deemed essential, but the vast majority of our workers were made to work remotely. That became an issue for technology purposes. It also became an issue of how do we protect their safety when our Adult Protective workers are supposed to go out and see our clients once a month. And they're supposed to be out there meeting with our clients to keep them safe and developing relationships with them. And how do we do that while protecting our workers' safety? Because from county standpoint, that's extremely important. Do we have sufficient personal protective equipment? And early, that was a real difficulty across the state because it was all going to medical providers. There was an issue as whether our workers should be tested when they're coming back and going out in the field. Again, technology has still been a struggle for some of our workers in getting them to work remotely. We're still developing plans on when they're coming back, how we're coming back into the offices. The second part, the safety of our clients. If we're trying to go out and visit with them, do they have protective equipment? Should we be going into their home? Are they medically vulnerable? A lot of our clients are. So we had to be very mindful of that. And we really came up, if cases were stable, we were really just trying to contact them by phone. And a lot of other clients, we were just trying to see them through windows and through doors and not exposing either our workers or the clients. We've also had COVID-19 referrals where we have people that are, someone in the family is at risk and may have been diagnosed, or someone else in the family, in the household, is diagnosed. And there's fears that they may be being put at risk by that family member because they're not being socially distant or taking proper precautions. So we've had a few of those cases as well. So it's been a matter of us trying to balance the risks to our clients and then also the safety that we're looking at with just the existence of COVID. Next slide, please. So one of the biggest things that we deal with elder abuse too is isolation of our clients. And that's a big role that we develop in trying to develop relations and getting them into the services that they need. In this time of isolation, we're telling older, vulnerable clients that they need to stay isolated, that they shouldn't be having contact with family and friends. Banks were closed, senior centers closed, doctor's appointments. They either became virtual, they simply were being canceled, or they weren't happening. Some of our surgeries that were happening, we know people weren't going to the doctors often or the emergency room even if they should have been going. And just trying to, for adult protective, we rely on our members of the community to make referrals to us so we know if someone is at risk. And if they're not being seen by family or friends or banks or others, or doctors make a lot of referrals to us too, we just may not be finding someone that's at risk. Also, we're fearful about their inability to safely report from perpetrators. When families are together, our largest number of perpetrators are family members. We know that. So if they're being isolated away from everyone else, but with the perpetrator, how do we know what's happening there? Statewide, we have seen referrals to adult protective services were reduced after we really shut down. We're starting to see now our referrals are definitely on the rise up. We were, up until we hit March, our numbers of referrals were up over last year. Last year's were up over the year before that. It's on a continuing upward trend. But for this time period, there was definitely a lull and definitely cases not being reported. Our anticipation is that we're going to, as we continue to open up, we're going to see a wave of more exploitation cases and abuse cases reported to us and to law enforcement as well. Melanie and Jordan talked about developing relationship and evaluating capacity requires time. How are we doing that? On the phone or not observing the inside of someone's home to see what's actually happening inside the house that's creating issues. Obtaining documentation is taking longer, not only because of staff priorities at the banks, our priorities, and actually a lot of our workers working remotely. So that's slowed that process down on getting documentation too. Next slide. For court and me, I already mentioned ability to file new proceedings. We were extremely limited in what we could do. We had to make a determination that something was I was using the term essential. That's really what the state was saying, but it was really the idea of emergency versus non-emergency. And if I had a case where there was an abuse of power of attorney and it's been going on for months, it was hard for me to make a statement that this was an emergency situation. So we really were kind of precluded from filing any of those. We have now been filing the ones that were backlogged, and we're just now starting to see some of them come on for court. So for guardianships, POA cases, trustees, those are proceeding. But again, they're being done remotely as of right now. And next slide. So what does that create? If we're trying to do a remote proceeding for someone that we're alleging lacks capacity, and we're saying that this person, you need to appear by Skype, and they lack capacity, raises a lot of issue. It's hard enough for, like I said, the court couldn't get Skype recording feature to work yesterday. We're expecting people that we're saying lack capacity to be able to do it on their own, because there's not really another way that someone's going to go in and set that up for them in their home. And for a lot of these proceedings, they get court-appointed attorneys, or there's a court evaluator. How are they going to have access to them to make sure their rights are preserved and their needs met? How are they going to get transportation to court? That's always an issue for us in any event, but it's just heightened when, because there is supposed to be a dedicated room at each court if someone truly doesn't have access to a computer, so they could set up Skype so they could appear. And then another issue, say we had a potential perpetrator as a financial exploitation case, and it's either a power of attorney case or a guardianship, and they're appearing by Skype. What about the potential presence of the perpetrator during the remote appearance? What if the person's in the room or in the home with them? And are they going to be able to testify safely, or will they be limited into what they're going to be able to say? And I think, Lori, we're getting closer to time, and I think that's it. So thank you very much. And Lori, I don't know if there's any other questions.
There were no other questions, so just going to give it a minute, and I'll stop sharing the screen so everyone can see our speakers again. And let me just...
While we're waiting for the questions, I'll ask Melanie, while she's up there, a question that, Jordan, how have your experiences been with Skype in the court system and getting everyone connected?
I haven't had an issue, but I've certainly heard anecdotally other people who have. But they aren't doing a lot of our appearances. If the defendant is out of custody, then the defendant has not been appearing. It's just been counsel meetings. And then they've got, over at the jail, they've got a room for Skype, which actually tends to work pretty well. Jordan, I don't know if you agree or not.
I haven't had any problems specifically with it. It's just, yeah, I mean, it's mostly been difficult with cases where defendants aren't in custody because there's no way to really get everybody together to try to move things.
Well, okay, thank you, all three of you, for that really, really helpful, informative information. So I want to thank our speakers, Melanie, Morgan, and Jordan, and our sign language interpreter, Tessa. We don't have any questions, so at this point, I will say goodbye, and thanks again, and I hope everyone has a good rest of the day.
Thank you.
Bye, thank you.
Bye, thank you.